In this video we are going to let you know the comparison between fiancé visa and marriage visa, and we will also try to explain which is better for you.
Visit our Swat&Vee channel with your questions to see how best we can help you out your process. Please don't forget to subscribe if you're new to the channel.
Let's get into the video. When a U.S. citizen marries a foreign citizen, there are fundamentally two different ways for the foreign citizen to immigrate to the United States and obtain a green card. The choice, a fiancé visa or marriage visa, can cause confusion for many couples. Each has its own benefits. So what's best for one couple may not be ideal for another couple's situation. In making your decision, you'll need to consider speed of the process, cost, as well as other factors. From this video, you'll learn about the differences, pros, and cons of a fiancé visa and a marriage visa, so you and your fiancé may make an informed decision about the best option for your situation. Remember that every couple has their preferences and constraints to consider. Your marriage story is unique. Your journey may differ from that of other couples. Let's know about fiancé visa. The fiancé visa, formerly known as IR1 visa, is a method used for foreign citizens engaged to a U.S. citizen to enter the United States for the specific purpose of marrying that U.S. citizen. Once married, the foreign spouse must go through a process called adjustment of status, if he or she wants to obtain a green card. Reasons you may consider a K1 fiancé visa. You plan on getting married in the United States. You need to get married in the United States because your fiancé's country does not legally allow your union. You would like to be married as soon as possible. Your partner is a U.S. citizen, not an LPR. You want a faster process of obtaining residency status compared to a marriage visa. Fiancé visa eligibility. It is the U.S. citizen who will file on behalf of their foreign national fiancé. In order for you to be eligible to petition for your partner, you must be a U.S. citizen and provide evidence of such. You and your fiancé intend to marry within the 90-day timeline of admission into the U.S. You and your fiancé have met in person at least one time in the 2 years prior to the time you petition for the K1 visa. If you have questions about the evidence you need to include to verify your eligibility, speak with your immigration lawyer today. Fiancé visa process. The process begins with the U.S. citizen fiancé petitioning the U.S. government to grant a fiancé visa. The U.S. citizen must file Form I-129F, Petition for Alien Fiancé, with U.S. Citizenship and Immigration Services. Once the petition is approved, a visa interview will be scheduled at the U.S. consulate office in the foreign fiancé's country. Next, the consulate will issue a fiancé visa if everything goes well in the interview. But you must use the visa to enter the United States within 6 months of its issuance, otherwise it will expire. The K1 is a non-immigrant visa. That means it does not permit the immigrant to stay in the U.S. permanently. Its sole purpose is to allow the fiancé to enter for the purpose of marriage to a U.S. citizen. Then, after entering the United States on your fiancé visa, you'll need to get married, and start working on an Adjustment of Status, AOS, application. Adjustment of status is the process that the foreign spouse uses to request a change in immigration status to that of a permanent resident. An immigrant who has successfully filed the Adjustment of Status application is allowed to live legally in the United States while awaiting an interview at a USCIS office. If you do not apply to adjust status within 90 days of the marriage, you will be required to leave the U.S. Your K1 status will cease, and you will be in direct violation of the terms of your visa. If you stay beyond the terms of the visa, it will likely make the K1 subject to deportation and negatively impact the fiancé's ability to obtain permanent resident status in the future. If you and your spouse plan to live in the U.S., a timely filing the Adjustment of Status packet is absolutely critical. Many couples prefer the Adjustment of Status process because you can go through the entire process of obtaining a green card from within the United States, provided that you're already here on a legal basis, such as a valid fiancé visa. Let's know about marriage visa. A marriage visa is a green card for eligible spouses of a U.S. citizen or lawful permanent resident. If you take this route, you will marry outside of the United States and apply for a family sponsorship immigration because your spouse is now your immediate family. This is known as the IR1 or County Route 1 process. There is also the marriage visa called a K3 spouse visa, which allows your spouse to legally enter and stay in the United States while USCIS processes their permanent resident application. If the LPR or U.S. citizen spouse needs to return to the United States, this is the quickest way to be reunited with your spouse. The K3 visa is a non-immigrant visa, meaning it is temporary. This visa is similar to the Fiance visa, but has important contingencies that differentiate the two, such as having already been married. The marriage visa can open up various opportunities for newlyweds, including the option for lawful permanent residents to bring a spouse to the United States. Fiancé visas are only available to U.S. citizens and their foreign national fiancé. LPRs cannot bring a foreign national fiancé to the United States. LPRs can use a marriage visa to petition for their foreign national fiancé to join them in the United States so that they can become lawful permanent residents. Reasons you may consider a marriage visa. You are a lawful permanent resident and wish to have your significant other also become a lawful permanent resident. You and your spouse wish to be married in a different country. The U.S. citizen or permanent resident does not need to return to the U.S. right away. Marriage visa eligibility. Like the fiancé visa, the U.S. citizen petitions on behalf of their spouse. To petition for your spouse, you need to meet the following qualifications. You are a U.S. citizen or lawful permanent resident. You have a qualifying relationship, in this case your spouse, and prove that your marriage is legitimate through supporting evidence. You can prove that you are 125% or more above the poverty line in order to support the applicant. A significant difference when considering K1 versus K3 visa is that a marriage visa allows spouses of LPRs also to gain permanent residency in the U.S., while the fiancé visa does not. Marriage visa process. There are two different ways to the marriage visa application process, which you will learn about below. In both cases, you and your spouse will marry outside of the United States. In either case, you must file Form I-130, Petition for Relative. Applying for the K3 visa is in addition to the main marriage visa process. IR1 or CR1. The process of bringing your spouse to the United States results in their permanent residency. Three main visa forms are involved in accomplishing that. Marriage visas use a process called consular processing, which is applying for a green card from your home country. The U.S. citizen or LPR will file Form I-130, Petition for Relative. If you choose, you can also submit Form I-485, Application to Register Permanent Resident, simultaneously. You will also need to include a Form I-864, Affidavit of Support. Note that when Form I-130 is processed and approved, that is just the start of the LPR process. The foreign national fiancé will not have permanent residency yet. The form verifies the relationship. Next comes the biometrics appointment, where USCIS will perform background checks and gather other information. The consular interview comes after, where the foreign national spouse will go to the closest U.S. embassy or consulate. The interviewee will ask you questions to see if you are inadmissible and/or if your marriage is legitimate. If everything goes well, you will get your application approved and a visa granted. This process can take a very long time, so it's crucial to work with an experienced attorney to support you in each step. Process of K3 spousal visa. A K3 spousal visa is an excellent option for foreign national spouses who need to travel abroad after entering the United States, as well as remain united and live in the United States while their marriage visa is being processed. As stated above, the K3 visa is in addition to the County Route 1 visa, not in replacement. Once you file a petition for your spouse to become an LPR in the U.S., the foreign national spouse can apply for a non-immigrant K3 visa. The K3 visa allows the foreign national spouse to legally live and work in the U.S. while the marriage visa is pending approval. Once Form I-130, Petition for Relative, is submitted by the U.S. citizen or LPR, the foreign national spouse will file Form I-129F, Petition for Fiancé. Fiancé visa or immigrant visa. Which is the best choice? To determine which path is best for you, fiancé visa or immigrant visa, depends on many factors and is a personal decision. Here are several issues to consider. Number 1. Place of marriage. The purpose of the K1 fiancé visa is to come to the U.S. for marriage. So if the couple desires to marry inside the United States, this is generally the best path. This method does require some planning. Again, the marriage and adjustment of status filing must take place in the U.S. within the 90 days of the K-1's admission to the United States. If your preference is a marriage outside the United States, the K-1 visa probably is not the best option. Keep in mind, it is acceptable to have an unofficial wedding reception or religious ceremony that is not legally binding abroad, then come to the U.S. to be legally married. Number 2. Speed of marriage. If your priority is to become married as soon as possible, it will generally be quicker to marry outside the United States. Obtaining a K-1 visa, typically the fastest way to the U.S., will take approximately 5 to 10 months. So visiting the fiancé in his or her home country will usually be faster. Number 3. Speed of U.S. presence. If the goal is for the couple to be together in the U.S. as soon as possible, the K-1 visa is most likely the fast path. From the date of filing to the date of admission to the U.S., it will take approximately 5 to 10 months on a K-1 fiancé visa. On the other hand, the marriage visa may take 10 to 16 months. However, if the U.S. citizen spouse resides abroad, it may be even faster to request the immigrant visa by filing the I-130 with a USCIS international office. Number 4. Filing fees. Cost is also a large factor in your choice. Fiancé visas are typically more expensive than marriage visas. There are price variations, so this is simply an estimate and is subject to change. These prices take into consideration form and processing fees. Most fiancé visas can cost around $2,000 to $3,000. Most marriage visas can cost around $1,200 to $2,500. Talk with your immigration attorney about the cost breakdown and what is best for you and your fiancé. Number 5. International travel. If the immigrant fiancé travels often, this factor should be considered when deciding between the fiancé visa or marriage visa path. A K-1 visa is valid for a single entry. International travel is not permitted until the foreign spouse files a Form I-485, application to adjust status, along with an application for advance parole. Advance parole is generally issued within 90 days of filing. If the foreign spouse travels abroad before an advance parole document is obtained, the adjustment of status application will be considered abandoned. But a County Route 1 or IR1 spouse that entered the U.S. with an immigrant visa can travel abroad immediately. An immigrant visa holder is a permanent resident upon admission to the U.S. Additionally, the K-3 visa facilitates international travel. It can be used for multiple entries to the U.S. and is valid for up to 2 years. These are just a few of the issues that a couple must evaluate when deciding on the fiancé visa or marriage visa. For many immigrant couples, speed is an important consideration, especially given the long wait times that are often involved with the immigration process. Before you begin, check the USCIS processing times for each petition. Many immigrants will be able to choose between several options for how to get into the country. Which one you'll want depends primarily on your particular needs and wants, as well as the current wait times that you'll encounter.
I hope you guys found this video extremely helpful. If you know anybody that could benefit from this information, definitely make sure to share this video with them. We are all about empowering you with knowledge. So the more people that can benefit from this video, the more people we want watching this video. If you like this video, please make sure to hit that thumbs icon. Thanks for watching, and don't forget to subscribe and hit on the notification bell for more immigration updates. Bye!